Hey, welcome. Disability Law Show. John Scholes along with Sivan Tumarkin here and ready to go. 1-855-821-5900. Anytime you want to reach out, you can do so. help@disabilityrights.ca. And for the next little while, or at least foreseeable future, covidrights.ca is a wonderful website for more information as well. Coming up on the show today, all kinds of good stuff. We'll get to some phone calls, some emails, and the top 3 things you need to know if your LTD, long-term disability insurer, is pressuring you to go back to work. That is on the way. First, pal, how are you?
I'm great, John. How are you?
I'm good. I'm ready to roll. Ready to roll.
Excellent. So let's start off with something that we've spoken about before, but I want to make sure that any new viewers of the program are aware of. So first of all, I'm a disability lawyer. This is the Disability Law Show, obviously. Now, it's important to understand that I practice in this area of law, and I've been practicing in this area of law with my colleagues at the firm for many years. And despite the COVID-19 pandemic, we are all operational. Everyone at our firm is working from home, working remotely. We have offices in Ontario and in BC. So if you or someone you know needs help with employment law, if they've been let go from a job and they're looking for severance and they're owed severance, or if they have a disability dispute with their insurance company, long-term disability insurance company, we can help. At the very least, we can give you information that is going to allow you to make the decision you need to make on how to proceed forward. Now, the issue I want to raise here, John, is limitation periods. I've had several people contact me this past week who were denied long-term disability. They can't work. They have either a physical or a psychological mental disability and they can't work. They applied for long-term disability. They had policies in place through work, and they were denied. And they were denied despite the fact that their doctors said that they were unable to work. They're disabled. So for all intents and purposes, the insurance companies, these individuals' insurance companies, ought to have paid them long-term disability, but they didn't. They denied their claims. So on the face of it, each one of these people that contacted me that I spoke with had a great case. But here's the problem with each one of these individual claims. They all happened over 2 years ago. The denials happened over 2 years ago. Now, in Ontario and in British Columbia, there is a 2-year limitation period for starting legal claims. Okay, I want to reiterate that. 2 years. That is when the clock starts and then ends at the 2-year mark. And if you try to start a claim after the 2-year mark, the insurance company can apply to a court to knock off your legal claim, to stop you from proceeding. Now the question then becomes, when does the clock start? When does the 2-year limitation period start? Some people who are dealing with a long-term disability dispute think that, okay, well, I was denied before, then I appealed that decision, then I got another denial to that appeal, I appealed again, and they think that those appeals, those denial of subsequent appeals, reset the clock. They do not. And we have a case from earlier this year in Ontario from the Court of Appeal called Clark versus Sun Life, where the Court of Appeal in Ontario, and despite the fact that it's in Ontario, I would say from a cautious standpoint, you want to make sure that in BC and in Ontario you follow this golden rule. You count the clock, or the clock starts ticking for your legal rights to expire as of the date of the first denial. So if you got a letter in the mail or by email or a voicemail from your adjuster or from the insurance company saying, we are denying your long-term disability claim, assume that that first denial, that first notice of denial is when the clock starts. So John, again, if today's January 1st, 2020, then January 1st, 2022 is when the limitation period expires, okay? So I couldn't help these individuals despite the fact that they had great claims. They were denied several years before that, and it's unfortunate because they continue to remain disabled, and by all accounts, the insurance companies basically kept tens of thousands of dollars that is owed to these individuals because these individuals did not take action, did not start a legal claim back then when they could have, and now it's too late.
And what never helps as well, that people not knowing, maybe they haven't seen this show or caught the radio show, they get mired in the whole appeal process, and that gets them absolutely nowhere. It wastes time.
Right. Yep. Time. These appeals are dangerous. They're dangerous. You're entitled to appeal, but these appeals in my experience, for the most part, go nowhere. I call them detours because generally when people contact us, it's after seeing the show or listening to us on the radio or just Googling this information. Although be careful of what you find on Google. Not all the information you find is accurate. You need to understand that when the insurance company denies your claim or when they cut you off benefits and they invite you to appeal, that is not some third party that they're telling you that's going to look again at the material. It's them. It's the same people who denied you in the first place. You're asking them to reconsider their denial. What is their incentive to say yes?
Yeah.
What? So unless you have a tremendous amount of new documentation, unless there's a real big change here in the equation, there's really no reason for the insurance company to approve you. And you're right, John, those appeals, they'll drag out the process. They'll drag out the timeline, and some people end up doing 2, 3, even 4 appeals and get really close and sometimes over the line for that 2-year mark. And again, once you cross that 2-year mark threshold, the chances are you will not be able to recover any of the money that is owed to you.
Well, you did mention the radio show in that last speech of yours, and there's a way to find it and catch the radio show. DisabilityRights.ca is the source for that, and we take the phone calls from that show, the radio shows, and play them back here, and we dissect them. First call of the day, pals, coming up right now.
My problem now is that I'm on disability, and I am also getting CPP. The company I have been working for is now shut down and no longer. I have now also become very sick. I am now on for about for another maybe 6 to 7 more months on my long-term disability. And they told me that I will come to an end by the end of this year. But they did not give me any information. They're just saying this is how long my disability is going to be.
Mm-hmm. So, John, a lot of people are concerned that, once they're on disability, what happens with their employment? In this case, this individual, his company's shutting down. He's on LTD. He's on disability. He's getting those benefits, but he's been told that his benefits will end at the end of the year. Okay, first of all, the fact that a company shuts down, goes bankrupt, whatever the reason is, should not affect your LTD if you're already on LTD. The only way that you can stop getting long-term disability benefits once you're on the program is either if you're no longer disabled or if you've arrived at the expiry of the policy, meaning let's say that your policy takes you to age 65 and you are 64 now. Let's say this gentleman is 64. I don't know how old he is, but let's say he is. And the insurance company says, well, you turn 65 at the end of the year. That's when under the policy, the LTD policy, your benefits expire or they stop. Well, at that point, as per the policy, the benefits will in fact stop. But many individuals are told by their insurance companies that their benefits will end at some future date. Let's say a few weeks from now, a few months from now, at the end of the year, whatever it is. But the person is not turning 65. They're still disabled. So then the question is, well, why? Why are my benefits ending? Right. You need to get a reason from the insurance company. In many instances, the reason is because you get close to that 2-year mark. That 2-year mark of being on LTD, that's when the test for disability changes from your own occupation to any occupation, meaning that you have to now show not only that you cannot do your own occupation, but you can't do any occupation for which you're suited for by training, education, or experience. But most people believe, for whatever reason, well, because they're not explained by the insurance company, that their benefits just end. No, the benefits don't just end. There has to be a reason for that. And if you have questions as to whether or not the reason you're given is legitimate, give us a call. Give us a call, email me, contact me. I'll tell you in minutes, sometimes even seconds, whether or not that denial or that cutoff of benefits is legitimate or not. And if it's not legitimate and you should not be cut off benefits, I'll tell you that and then you can decide what you want to do. But I'll be giving you options and it's free. It doesn't cost you anything to speak with us about this. So there's really no reason, John, for people not to contact us with questions because, again, this information is free and it's accurate and it's for the benefit of the public.
And I think something else this caller put in there as well, and I guess you can call it a safety net, or at least he's got a little bit of satisfaction that he's on CPP disability as well. So that doesn't follow in lockstep with his private insurer at all, does it?
No, it doesn't. It doesn't. And that's why I tell people who are on LTD to also apply for CPP disability. You're not going to get the benefit of that from a financial standpoint. Remember, the insurance company gets credit for any CPP payments you get, but What it does do is it gives you that lifeline, right, in the event that you are caught off LTD and we have to fight them. And generally, it doesn't take us long to resolve LTD cases. Just so you're aware, okay? People out there think, I watch the movies, these things go to trial, they take years. No, they don't. The vast majority of these cases, I'm talking now from the perspective of my firm and my lawyers. Yeah. We're very proactive. The vast majority of cases resolve within weeks or months of us getting involved. Okay? They don't take years except for the rarest of circumstances at our firm. I can't speak for other lawyers. I do know that some lawyers and some firms, the majority of them, unfortunately, don't operate necessarily the way we do. But yeah, absolutely, John, CPP disability is very, very big for this person. And here's the thing. If we can help that person, I'm telling you, John, the fact that he's been told that he'll be cut off at the end of the year, we are now in May, we'll be able to help him. In fact, we may even be able to get to a resolution with his insurance company before he's cut off, which means he's not going to have a period of time where he doesn't have any money coming in. And that's really, really important, right? That's why I tell people, if you're told your LTD will be cut off, that it will end, don't wait until that happens to contact us. Let us know now. We may be able to step in now and avoid you having a gap in terms of the money coming in.
3 things you need to know if your long-term disability insurer is pressuring you to go back to work. We'll cover that after a short break. In the meantime, 1-855-821-5900 and help at disabilityrights.ca to reach out as well. More of the Disability Law Show is on the way. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Disability Law Show. It's John Scholes, Sivan Tumarkin. Disabilityrights.ca is the website if you want to reach out and catch past shows and a radio show. Links to that as well. Let's get into this, pal. 3 things you need to know if your disability insurer is trying to force you back to work, trying to pressure you to get back to work. Number 1 is this. You don't have to go back if you or your doctor don't think you are ready to go back, right?
That's absolutely true. And I want to make something clear here, John. When people call me up and they say, look, I am being forced to go back to work, or sometimes they call me when they're at work and they say, I was forced to go back to work, I ask them, what do you mean by forced? Remember, the insurance company, the adjuster, is not going to come to your home, put a gun to your head, and force you to get out and get in your car and then go to work. They're not going to do that. What they will do, and they do quite often, is they apply pressure. That's very different than being forced. And I want to make that clear because when an insurance company applies pressure on you to go back to work, we can apply counter pressure on them, okay? Now, you do not have to go back to work if you're not ready. That's just a fact. You don't. More so if your doctor says that you're not ready, right? I mean, if you go back to work against medical advice, you are putting your health in danger. You're putting yourself at risk. You could get worse. So you should be following your doctor's advice. Frankly, the insurance company should not be telling you to do something contrary to what your doctors are telling you. I know this happens all the time. Insurers always, not always, many times do this. They'll tell someone, you should be going back to work even though the doctor is saying you should not be going back to work. Or they say you should be taking this medication even though the person's doctor says you should not be taking this medication. Follow your doctor's advice. That is the point, okay? The insurance company cannot force you. They cannot force you to go back to work. If you're not ready, do not go.
The second one, and you've already touched on it, is this. They can't physically force you to go back to work. They're going to pressure you, but they can't force you. Expand on that.
So I want to make sure people understand when an insurance company pressures someone, how do they do that? What's the pressure lever that they use? It's very simple. The pressure lever is we're going to cut off your benefits. They're going to end. You have an obligation under the policy to mitigate, they'll tell you, right? They'll use that fancy word, mitigation, that legal term. Here's the thing. Yes, it's true. The insurance policy that you have with your insurance company or that your employer has contains provisions that talk about mitigation, meaning you have to try and go through rehabilitation, get treatments, you have to go to work if you are ready to go to work. There is no policy out there, there is no provision in any policy I have ever seen that says that if you are not ready, you have to go back to work. So when the insurance company then tries to pressure you to go back to work by telling you you're going to be cut off if you don't, I take that as a breach of their obligations to you, the disabled individual. What flows from that is the counter pressure that I was referring to at the beginning, John, which is that if the insurance company is breaching its obligation under the policy, its obligation meaning to be that safety net for you, well, then you have a remedy. That remedy is a legal remedy. If the insurance company says your benefits will be cut off as of June 1st if by May 31st you don't go back to work, well, hold on for a second. If you've now given that specific date to this individual and he's unable or she's unable to go back to work because they're not ready and their doctor says that they're not ready, then you, insurance company, have breached their obligations. We can now take legal action against you even though June 1st has not arrived yet. Right. You understand? The insurance company can only apply pressure. They cannot force you. Very, very important. You have a lot more power than you think to apply that counter pressure on them.
We're talking about the 3 things you need to know if your long-term disability insurer is pressuring you to go back to work. Number 3 is this, pal. You got to start laying the groundwork for Plan B. And Plan B is if you try to go back and you fail, you're not ready.
Yeah, so when I deal with insurance companies, one of the things that I enjoy in my line of work is the chess game that goes on, the legal chess, right? I mean, when a client comes to me, the facts are the facts. The disability is a disability. The individual, the insurance company, I mean, I have to deal with whatever facts I'm presented with. However, it is up to me as the lawyer. This is what I do. This is what the lawyering art is to, in my mind, outmaneuver the insurance company for the benefit of my client. So when you hire me, when you hire our team, what we do is we use the weaknesses of the insurance company against them. One of the ways we do that is by giving this information to individuals. So what's this Plan B? What's this plan? You've decided you're going to try and go back to work. What should you be doing to lay the groundwork in the event that your attempt to go back to work is not successful and you have to go back on LTD? First of all, understand that in most insurance policies, in fact, every insurance policy I have seen that deals with long-term disability, there is a recurrence clause. That means that if within a certain amount of time, typically it's 6 months, but it depends on the policy, if you're unable to continue with the return to work attempt, you should be, because of your disability, you should be able to go back on LTD. The insurance company should not require you to reapply or to wait the initial elimination period. So that means that when your doctor clears you to go back to work, your doctor, when he or she is preparing the paperwork, giving you a letter saying you're ready to go back to work, they should not be saying you're ready to go back to work unless that's absolutely true. Instead, what I think they should be saying is you are ready to try to go back to work. That's very important. The word try is very important because then the insurance company subsequently, if you need to go back on LTD, can't point at the original letter from the doctor and say, oh, wait a second, your doctor said you're ready to go back. We're not going to put you back on LTD. And you point to that letter, right? This is that chess move that you've made that move initially that will then help you down the road with the assistance of your doctor. You point to that letter and say, no, the doctor specifically said I am going to try to go back. Now, let's fast forward, John. You've gone to work. You're having difficulties at work now. Mm-hmm. You don't know if you're going to be able to continue working. You want to make sure that your supervisor or the HR department, whoever's dealing with you at your workplace, is aware of your difficulties. You also want to provide that in real time, that progress, to your doctor by way of an email or text or whichever way you communicate with your doctor. You want to make sure that you provide progress updates to your supervisor and HR in writing and to your doctor, family doctor, psychologist, whoever. Again, This is important. This is that chess move. In the event that down the road you're unable to continue working, and you tell the insurance company, put me back on LTD, if they refuse, you can point now, going back in time, to all of those letters, all those correspondence, the emails, the texts that you had sent the supervisor, to the family doctor, to the psychologist, and say, look, I was letting them know along the way that I was having difficulties. The insurance company then would have a difficult time saying that you're now ready to go back to work. They would have a difficult time saying that you should be able to work, right? Because you've updated them along the way. You've updated the doctors, you've updated the supervisors. So it's really important to understand that you need that plan B. That plan B is what happens if the return to work attempt fails. That's the plan B. And many people don't understand that insurance companies oftentimes will refuse to put you back on LTD. But don't worry, because we can help when those situations arise. And John, we deal with those kinds of cases all the time.
Coming up here, are you still eligible for LTD if you are let go from your job during the application process? We will tackle that after a short break, so stick around for it. 1-855-821-5900 is the number to reach out anytime, and go to disabilityrights.ca as well.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Disability Law Show. John Scholes, Sivan Tumarkin, disabilityrights.ca, the place you want to go for more information and links to our long-running radio show. We take the phone calls from the radio show and we talk about them right here. That's how it works. Phone call number 2 is right now.
My wife had to apply for long-term disability because of mental illness, but she did that 2 weeks before she was let go from her job. Now, the frustrating thing is the insurance company said that she's not disabled. I mean, despite her family doctor and her psychiatrist saying that she is. And they said that she applied because she was about to be let go, but that's not true. I don't know how to help her. So, I mean, what can we do?
Well, this is an interesting situation here, right? Because there is a timing element here. The insurance company may be thinking that this individual's wife was about to be let go, and it's kind of convenient that suddenly she became disabled, right, before she was let go from her job. I actually, and I've seen this before, I've seen insurance companies put up this argument, and I think it's a wrong argument, obviously. And here's the thing that we need to understand, that insurance companies will use any excuse they can get their hands on or they can come up with to deny claims. And many of these excuses, they end up getting away with because people don't get the advice that they should be getting, like this gentleman is trying to do. So here's the answer here. First of all, we can help. We can help his wife 100%. If his wife's psychiatrist and family doctors say that she's disabled, that his wife's disabled, the insurance company ought to have approved her. Now, if the insurance company takes the position that she's not disabled, that it's convenient that she became disabled only a couple of weeks before she was let go, think about that for a second. If this ever went before a judge, the insurance company would have to convince the judge that the family doctor and psychiatrist were in on it, meaning that they were lying, that they had made up the fact that this lady became disabled exactly at that time, around that time frame before she was let go. No judge is going to buy that. No judge is going to think that the family doctor and psychiatrist are somehow lying. So the insurance company's argument is already dead on arrival. But it's important to understand that there is another element here. When you are dealing with someone that has been denied disability or been cut off benefits, And around that same time period, or at any point during that time period of a dispute with the insurance company, you are let go from your job, that raises the interplay that we often talk about between employment law and disability law. Remember that if you're let go from your job while you're disabled, that is illegal under the law. The employer is potentially exposed to a claim for human rights damages because it's illegal to let someone go who's disabled. Now, I don't know here if the employer was aware that this lady became disabled around that time. I mean, we don't have that information, but there is going to be a question here, John, about whether or not she's entitled to severance. She probably is entitled to severance. Right. And why that's important? Well, because if we go after the insurance company for the LTD benefits that she's owed, but at the same time, she gets severance from the employer, well, guess what? Most LTD policies contain provisions that entitle the insurance company to a credit for any severance that the person can be potentially getting. So, we have to be very careful on the timing and how we go for that severance, how we go after the employer for letting this individual go, this lady go. We may want to deal with the employer on the human rights angle because insurance companies can't touch human rights damages under most policies. So there's different ways to deal with the situation, but no question in my mind, John, that if someone is disabled and their doctors confirm that they're disabled, an insurance company should approve them for long-term disability. And if they don't, there is recourse. We can help you. It's not appeals. Mm-hmm. Okay, we talked about that. Do not appeal. Give me a call, email me. I'll ask you a few small questions. I'll want to see some of the paperwork, the denial letter, perhaps, the doctor's reports that you had sent the insurance company, and then I can tell you, literally over the phone, within a few minutes, whether or not you have a case or not. It's really not difficult.
I want to wrap up the show today, Sivan, with a quick email. Again, it is help@disabilityrights.ca. That is where you want to go. This one comes from Amy. Amy says, I'm immunocompromised because of a lung condition that I've been on LTD for over 5 years. Recently, a new adjuster took over my file and started asking a lot of the same questions I've answered hundreds of times before. But this lady is very condescending and disrespectful. She emailed me last Thursday saying that she doesn't think that I should be off work completely and that I could do something remotely like answer calls for companies who are working remotely now because of the pandemic. I'm a graphic designer by trade, so I don't know what she means. I used to earn close to $120,000 a year before my condition became disabling. And now, with COVID-19, I'm even more stressed than ever. I don't know what to do.
Well, John, I mean, we can see why Amy's stressed. Amy, I'm telling you right now, you should not be bullied by this adjuster. Confirm your conversations in writing with that adjuster. The fact that you've been on LTD for 5 years means that you've met that more difficult test of any occupation. Okay? That means that the insurance company has recognized for at least the last 3 years that you cannot do any occupation for which you're suited for by training, education, or experience. And generally, the mark for us, the litmus test for us to figure out if you can in fact qualify for that any occupation test is, can you earn commensurate income? Can you earn 60 to 65% of your pre-disability salary? If you can't, then that means that you should qualify for LTD and continue to qualify for it. And so this adjuster obviously has a mandate. She's probably trying to get several claims off her books. Maybe she's trying to get a bonus and look good to her bosses. Do not be bullied. John, this is something that comes up a lot. Individuals out there call me sometimes in tears, and sometimes it's the spouses of these individuals and other family members because adjusters are being very condescending. You have every right to complain about that kind of behavior. You have every right to push back, and you have the right to say, I'm not going to talk to you by phone. You want to communicate with me? It's in writing. Let's see how bold they are when you tell them you only communicate with me in writing. So remember, you have a lot more power than you think. Do not be bullied by the adjuster or by the insurance company. And if you need help and if you have questions, please call me, please email me. I will respond to you directly. Trust me, you have rights and we can help you enforce those rights.
DisabilityRights.ca is the website. You want to reach out through email. It is help@disabilityrights.ca. Appreciate all the contributions. You catch the radio show and the next time we do this show as well. Take care of yourself.